Hello friends, in the series on the income tax cases, today we will discuss a very important issue about the communications which are being there between the department itself on the income tax portal. Suppose DRP issues directions and these directions are uploaded on the income tax portal on 7th April 2022. So what will be the date when these directions will be assumed that it has been received by the assessment unit? In the present case, DRP issued the directions on 7th April 2022 and it was being uploaded on the portal on the same day. But the National Faceless Assessment Center sent these directions to the assessment unit on 2nd May 2022. In the present case, the limited issue was that whether the directions will be deemed to be issued on 7th April 2022 when these directions were uploaded by the DRP, or the date when these directions were sent by the National Faceless Assessment Center to the assessment unit on 2nd May 2022. So what will be the date which will be presumed to have been received by the assessment unit? This was the issue in this present case. The name of the case is Microsoft Corporation India Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 110 ITR Tribunal Short Notes 69, and the matter has been decided by Honorable ITAT Delhi I bench, and the date of the judgment is 28th February 2024. In this case, there were some transfer pricing issue. So the learned assessing officer referred the matter to the transfer pricing officer. Transfer pricing officer proposed some upward additions to which the assessee objected, and objections were filed before the dispute resolution panel. DRP gave some relief to the assessee, but some upward adjustments were sustained, and the DRP directions were uploaded on the ITBA portal on 7th April 2022. So according to the assessee, the assessment order should have been passed within 1 month from the end of the month in which the DRP directions are received, contrary to the timeliness which are there in section 153 or 153B, meaning thereby that even if there are some limitation period given by 153B, even then the assessing officer should have been passed the assessment order within 1 month from the end of the month in which the directions are received by the assessment unit. But the assessment order was passed on 30th June 2022, and the department was taking the plea that when these directions were received by the National Faceless Assessment Center, they have forwarded these directions to the assessment unit on 2nd May 2022. So the limitation period according to the revenue should have been computed from the end of the month of May, that is 30th June, and hence their order was valid. It was the contention of the revenue. But when this matter was in litigation before the tribunal said that on the conjoint reading of section 130 of the Income Tax Act, that is faceless jurisdiction of the income tax authorities, section 144B, faceless assessment, section 144C, reference to the dispute resolution panel, and section 15 of the Information Technology Act 2000, when all these sections are read in conjunction, then there should be taken an interpretation that once the directions are uploaded on the ITBA portal, that date will be deemed as the date of receipt of the directions by the assessment unit. So in case when these directions were uploaded on 7th April 2022, so this will be the date of the receipt of directions by the assessment unit. So the limitation period should have been calculated from 7th April 2022 and that will be 31st May, that is 1 month from the end of the month in which the directions are being issued by the DRP. Friends, this case is very important because nowadays, because there is so much complexity about the various limitation periods, even the department get confused. So the assessee has every right to take the benefit of this confusion on the part of the revenue, and we should know that how the limitation period will be calculated in various scenarios. So in the present case, the tribunal deleted all the additions and the assessment order was quashed just on the basis that it has not been passed within the limitation period which is being there in section 144C subsection 30. At the end of this deliberation, once again I am repeating the name of the case. The name of the case is Microsoft Corporation India Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 110 ITR Tribunal Short Notes 69. The matter has been decided by Delhi ITAT I bench and the date of the judgment is 28th February 2024. Thank you, friends.